Welcome to another segment of Buckingham Business Review. I'm your host, Bernie Wolford. Our video magazine is about the intersection of people, tactics, and strategy. This is our third segment with Mr. Ron Reardon. His firm is Patents & More. And if you have missed the first two segments, I strongly encourage you to go back and learn quite a bit, as I have learned, about this fascinating field of patents. Ron, in this segment, let's talk a little bit about the patent process itself. The timeline, the investment. I know there are different categories for which you can apply for a patent. What are some of the expectations of some of those issues that you need to communicate to someone who says, I need a patent?
Well, number one, Bernie, it's going to take a while because we're talking about the federal government, so
okay.
Nothing ever goes very quickly with them. Plus, the patent office is very busy. They've got a backlog of several years worth of patents. So
you said years. So.
Years,
okay,
that's right.
All right, so I've got to have a little bit of staying power.
Yeah, so you can become patent pending fairly quickly because it probably in a month or two of putting the patent application together and filing it, there'll be patent pending.
Okay.
But that simply means that there's a patent application at the patent office. You don't have any real protection or any rights granted by the government at that time.
Okay.
And so it ends up going to a particular area in the patent office. They call them art units. So there'll be an art unit for table saws. There'll be an art unit for clothing, and they're grouped by subject basically.
Sure.
And it will be put in a queue, and it'll be assigned to a particular examiner, and will be put at the very end of all of their list of things to do.
Yes.
And so as they take care of things, it'll work its way to the front. And that's why it takes 1, 2, 3, 4, sometimes 5 years, depending on the area that they've invented in.
Wow, wow.
And then the first thing that you get is called an office action, where 95% of the time they'll say, no, you can't have a patent. Mm-hmm. And so then we respond to that and say, you're incorrect and here's why, or we'll sit there and modify the claims in order to avoid the prior art that they found. And generally there's about 2 office actions. And then they'll give you a notice of allowance, and then you pay the allowance fees, and then that's when the patent will actually issue. However, sometimes you're not able to overcome the objections, and you don't get a patent. So there's always an element of risk that just because you file an application, just because it appears that you can get one, doesn't mean that you're going to get one.
Okay. Now, educate me and my viewers with regard to, I guess, date stamps. The day I file, the day that it's, I guess, received, patent pending, the day that I actually hold my patent. What if I discover that someone is a week or a couple days ahead of me in that process? Do they get it? Or is there some sort of a comparing my application to theirs? What's the process with regard to, I guess, really claiming it and being first to have it?
Yeah. Well, the old process, Bernie, was that the United States was a first to invent country. So
okay.
As long as you had an inventor's journal that was bound like a book and in ink, and you had documented when you came up with the idea and when you made improvements, you could use that to show that you invented it before anybody else. But the patent law was changed in 2011. And now it's more the first inventor to file. So whoever files first is the one that's going to be able to get the patent. And so that it's always a risk, since it takes 18 months from the time that you file a patent application before it actually becomes searchable on the internet. So you always have this 18-month window of invisibility, that I call it, that possibly somebody else has filed before you, and you won't know it until 18 months later.
Okay.
So just like business, you can't totally eliminate risk.
So if I'm hearing you correctly, I can see a widget, and I can say, that's a really, really neat widget. I can go and do a search and find out that nobody ever patented it. I file for the patent, and because I file before the current manufacturer of that widget, I'm first in line, even though it's in the marketplace?
No, that's not correct.
That's not correct. Okay.
Because it's first inventor to file. And so when you see a widget,
okay.
You didn't invent the widget. Only the inventor can file a patent application for their invention.
Okay.
Now, if you saw a widget and you said, hey, that widget needs to have a propeller or lights or a GPS chip attached, and so you have a concept that you add to it,
making it better,
then improving it. Then you're the inventor of the improvement, not
Okay.
of the widget, but the widget with the improvement.
Okay. Tell me a little bit about developing and holding and using patents as a business strategy. Urban legend has it that Microsoft, IBM, Apple, some of these guys make a lot of money off the very ownership and licensing of patents. Is that urban legend, or is that true? That's a big part of business.
No, that's an actual strategy, and there are lots of companies that they collect patents. They purchase patent portfolios in order to monetize those by telling other companies, hey, you're infringing on these patents, because it might be that patent 1 nobody's infringing on, but if you get patent 1 plus patent 2 plus patent
Gotcha.
3, then there's infringement, and that can be a revenue stream. And especially large companies like the ones you've mentioned, whenever they get into lawsuits or get into acquisitions or whatever, a lot of times they'll swap patent portfolios. So company A will sit there and say, well, you're infringing, and company B says, no, we're not. And before it ever goes to court, they'll say, tell you what, let's quit paying the lawyers. Yeah, we'll license ours to you, and you license yours to us, and we'll call it quits.
Fascinating, fascinating. Well, we're visiting with Ron Reardon of Patents and More, and I am thoroughly enjoying becoming educated in this whole field of study of patents. And we've twisted Ron's arm, and he has agreed to come back and do one bonus segment with us. So we hope you will join us again for that segment on Buckingham Business Review. So long for now.